Welcome to Property Quorum. My name is Gareth. I'm delighted to welcome in the usual stalwarts of Property Quorum. We have Hamish McLay from Convey, Juliet Baboolal, the partner of gunnercooke, and Gilsenan of Root Home, representing three, I would say, parts of the property mess that there is out there that like working together towards one goal, which is easy transfer, building, refurb, and promotion of properties of many different types. And today we have a special guest of Zahrah Aullybocus, and here she is.
Hi.
Of NEXA. Now, Juliet is our legal eagle. We've got two legal eagles in the house. And today's topic is, as per usual, a humdinger. It is, of course, the stranglehold of Leasehold. So I'm afraid I'm going to throw Hamish straight under the bus and ask him to explain what in heaven's name we mean by that.
Well, it's probably appropriate that in the misty morning light, looking into the mysteries of Leasehold. From what I understand, and probably being the age that I am, I should have been there around about when sort of leaseholds took birth, but
just after the earth cooled. Yes.
But it does sting. Being a Scotsman, although I don't sound it, being a Scotsman, that gives it all away. It sort of stems back to this sort of historical knowledge of the English grabbing hold of all the Scots land and sort of throwing them out for the Highland clearances and sort of stuff like that. So it goes back in history. But to me, it's still a total mystery, the whole sort of thing. But it's really strangling so many people now because of, although it was historical and some of that was difficult to unravel, things like the Building Safety Act have really caused some mayhem. And it's good that we have those who know something about it and have a brain to resolve these matters, with the likes of Zahrah here, with the likes of sort of Juliet that can understand and sort of unravel it, not just for the likes of me, but for those listening in to sort of perhaps take something away from the mystique.
Well, I'm going to grab Juliet immediately and say, what in heavens are you referring to, Juliet?
You know, when you have a leasehold property, unless you've actually purchased one, it's very difficult to, or you're a lawyer yourself, it's very difficult to understand the terms within a lease, because often people see words, they see papers, and they sort of, get a mind block. And it's really important to read that document and understand what it says, yes, but it's very draconian. And by that, I mean very old school. I remember acting for someone once, and we were trying to sell a lease, and there was a restriction on the lease saying that it could only be sold to a caretaker of that building. And although it hadn't applied anymore, it technically meant on a strict basis we couldn't sell the lease and had to have it varied, which cost, So really, it's really important. Again, we bang on this about getting the right representation, but you are investing in this leasehold property. It's essential that you read that lease cover to cover, understand how it can be terminated, understand how you're affected in terms of service charges, etc. Yes, your lawyer's there to handhold you, but often what I found, Gareth, is that sometimes someone might buy a new build property and everything's under warranty, so they don't really service charges are all about. And then these warranties expire, all these service charges start skyrocketing because things need to be fixed, etc. So, do your research in terms of reading that thing cover to cover. Yes, you've got a lawyer, but, there's certain practical elements. You're the one investing in this property. You're the one potentially going to be living at that property. That's another thing. The other week we spoke about shared ownerships. There are loads of shared ownership people who don't realize that there is a restriction on subletting. You can't sublet your lease unless you get consent from the housing association. So read your lease. Every lease is different, but it's your investment. And so the onus is on you, irrespective of how long or lengthy the document is, to read it and understand it.
Zahrah, ancient but necessary piece of documentation, it seems.
It's Well, it's something that there's a lot of campaigning to get rid of. So the government created Common Hold back in 2002, and there's not been a great big take up. And that's because leasehold is a great mechanism for people to make money. Going back to what Juliet just said, new builds might seem attractive because the service charges are low, but I've seen out there in practice that the developers are purposely putting the service charges figures out as lower than they actually are to be able to sell the properties. And so not even within the expiry of the warranty period, within a year or two, those service charges are skyrocketing.
This sounds this sounds duplicitous. You're saying people are lying?
Well, there was a lady out on X who said she was a former estate manager, and she just couldn't live with herself because she was being asked to twiddle the figures. So that all of this is going on. Who's doing it and why? And I'm not out there throwing accusations, but there needs to be more transparency. You would expect a new build property to have lower service charges, but what we're finding is that these properties are being put up, built with spit, lots of corners cut. For example, a lady that I went to Parliament with last year, she was talking about the holes in her. She was talking about the walls in her flat being cut open, and instead of finding fire safety insulation, the builders had left beer cans in the walls. So
cans?
Yes. So you're paying for what you have bought in good faith, something that to call your home that you expect to be safe. Fire safety is there for a reason. And basically the way that leasehold works is that these guys know that, they can sort of develop these properties, liquidate the company and move on. So when you go back to try and sue them, nobody's got any money. There's no money there. So all these people are left with defective buildings that they're going to have to pay to fix themselves, which is going to cost thousands and thousands of pounds.
Yikes.
So the government put in the Building Safety Act, which has caused even more problems. And they're going, oh yes, you guys, you've got protections, you don't have to pay. But actually, when you look at it, if you've got a building full of 10 flats, if you've got 5 of them that are qualifying leaseholders, the person who owns the building is going to have to find that money from somewhere to fix the building. And what happens if they go insolvent? We're at a conveyancing stalemate. We're not going to be able to buy or sell these properties because we know the work needs to be done. It's not being done. And what mortgage lender is going to take a bet on getting their money back if they give, Joe Bloggs this money to buy the property?
Chris, do you find many of your buildings' walls are full of beer cans?
If I found out the builders were drinking on the job, I'd flip. That's outrageous. But yeah, at least we work with a lot of overseas investors, and when they don't understand what leasehold is, and when you're trying to explain it to them, they're like, "I don't want that." So,
well, it does sound at first sight, it does sound like a thing nobody would want.
Well, it's got a few challenges. So Juliet's already alluded to some of the challenges with some of the onerous restrictions that are in leasehold documents. We've had our fingers burnt and not explaining ourselves correctly to our solicitors or with our exit intentions for a property, purchasing property and it not being able to deliver it based on what our original intent was because of the restrictions in the lease. And they can be just spurious. Some of the reasons. I mean, the one that Juliet mentioned, that was one I've never heard of, but hilarious.
That was nutty. That's absolutely nutty.
So it's not surprising that leasehold reform has been on the cards for a while, and so the government has made some changes that have had impacts on the industry. So they've been staggering it and probably waiting for the big one that they're doing at the moment. Which they still seem to be spinning like a spinning top on and changing directions every 10 minutes. But the banning of the ground rents on new developments, that's good because there was a scandal in not just down the road from me actually in Knowsley on ground rents, where I think the developer written into the contract that they double every 10 years, which doesn't sound onerous to start with, but I'm sure, as you're aware, if you double a penny,
Oh
keep
God,
doubling
yeah,
that,
it's that
it gets
classic one that
insane.
if you double the amount of grains on every square of a chessboard, by the time you get to the end, you've got an incalculable number. Yes, nutty, and also a rather insidious sort of backhand money making scheme, I would have thought.
Well, this is the challenge, that so many people have been making money and in different avenues through this for such a long time. So you've got people who are buying up ground rents. I know a developer who was literally buying up ground rents and has built a company off the back of it, and then sold these packaged onto real estate investment trusts or institutional investors, so big insurance companies and the pension funds, because they provide a stable income. And with the ground, I can't remember the actual act that came in a couple of years ago, back in 2022, but it effectively put a stop to their entire business. So anything moving forwards, and then as part of the recent legislation proposals, the bill that was going through, Gove, I believe, was suggesting wiping the floor with any ground rents moving retrospectively. So I think all the insurance companies were completely up in the air about it, because they were saying, well, we've spent billions on all these purchases. You're saying you're going to just wipe the debt on it? Well, there's zero in it. It's like, so there are lots and lots of intricacies as you go through it, and appreciated that ultimately it's the leaseholders that are footing the bill. But is that bill fair?
Is that bill fair, Hamish?
I would suggest, unlike many other things in life, there's no way of measuring completely what proportion is being hit by what is going on, but it's seriously damning so many people in terms of where they are living, which is why it's so critical. I mean, Juliet says about, yes, it's important that the client should. I would hate to have to read through a leasehold agreement. I remember getting a copy of a leasehold agreement from one of my clients, and I couldn't believe how many pages were in it. I thought, I'm glad I got it for him to read and not for me. But it's the likes of something like Zahrah, for example, who does an awful lot of work on that particular side of things. But we do need people like Zahrah. We do need people like Juliet, because they're the guiding light in all of this. And probably, as Chris would admit to as well, getting the knowledge from people like that does really take the haze away from it, take the fright away from it.
Oh no, Chris and I have many times spoken on our own separate podcasts the absolute necessity of surrounding yourself with people who know better than you. Zahrah, is there any hope? It just feels a bit horrible, really.
Well, I think all we can do is support the campaigners, because they will keep pushing. They're not going to give up. Michael Gove has definitely got a fight on his hands, because he's not a jar of Nutella. He can't keep everyone happy. So, he's going to have to carefully balance, leaseholders' interests against the freeholders' interest. The freeholders are not going to go down without a fight, because, they're entitled to make money, aren't they? And as previous case law has sort of said, you sign this agreement, you pay up now. But they kind of need to force this into a kind of avenue whereby there is a resolution, a legal resolution that people can, pay for to rectify the agreement to make the property sellable again. But from my point of view, in the last sort of 20, 30 years since I've been doing this, it's just got the new build stuff has just got bigger and bigger and bigger. So it looks like, even if you're buying a freehold property, it looks like you have lifted the provisions of a lease into a freehold property, so they're becoming that much onerous. And we're accused of causing delays, but hang on a minute. We've had hundreds and thousands of properties built within the last 20, 30 years. And all of these sites need you to go off to a third party to get information. Our job is that much more complicated, because I sometimes see 2 or 3 different companies involved on one property. It could be a flat and it could be a house. It just, you know, the amount of paperwork involved, but we've got the opposite quandary as well, that people are thinking, hang on a minute, it's just a piece of paper, just sign it and off we go. It's not just a piece of paper. And there are those that kind of think, oh, it's a tick box exercise, tick, tick, tick. And it's not that either. People need to know what they're walking into.
Juliet, I've just had a couple of messages pop up from a gentleman I know called Jonathan McDonald. He says he's trapped in a leasehold and the service charge has tripled. Well, that's not that uncommon. But what he also says, if it gets below 100 years, it negatively affects resale value. What's to do?
Well, you know, this is where it all comes in, Gareth. When my first investment property was a leasehold property, and the first thing I did was to become a director of the management company, or, you know, so that I could have a say level of service charges, etc. You know, again, certain leases at a certain level are not mortgageable, so that's the risk that you run. You know, he's going to have to extend his lease. He's going to have to make inquiries in terms of the requirements to extend and the costs. That's going to be a cost element. If he's got a mortgage, that's also potentially an issue. But, you know, I can only re-echo what we've all said. So many elements within the lease. You're paying a premium for this, and ultimately you want to have the ability to sell it on with value. And if there are sort of ground rents that are doubling, I mean, there's a rule which says if the ground rent doubles, there's a certain limit in London and a certain limit outside of London, but it becomes an AST, and a short hold tenancy, which means that the landlord can kick you out if you haven't paid your ground rent. And there's sometimes insurance that will cover it, but what the insurance covers is the litigation that might happen. It doesn't cover anything else. So some lenders, you're doing yourself out of a potential ability to finance the lease or to sell it, because some lenders just wouldn't touch that sort of lease. And so it is essential that there is leasehold reform. But, you know, transparency here is key, where, you know, the leaseholder knows exactly what they're getting into, and the freeholder should not be able to benefit twice. For example, I mean, you're being paid a premium for selling off a unit, and now you want ground rent. What exactly are you doing in exchange for this ground rent that we are paying? So, you know, I empathize with Jonathan, because often you see that, especially sort of in London, where people tend to want to buy leases with less years remaining on there. They'll buy it cash.
Right, of course.
Extending. But then when you come to extending, the requirements are onerous, and obviously the premium is quite high, and they're unable to negotiate terms. So what then happens? Do you then lose your lease? And that's where getting, you know, sound advice is really, really important. But there are lots of complications. I mean, I can tell you so many things. I mean, rooftop developments, people get leases for rooftop developments. You've got to serve special notices on the other lessees within the building before you actually grant this lease of a rooftop. There's so many sort of complicated things that, you know, it is essential that you do your homework before getting involved, because while the figures may seem, especially for a developer, they may seem to stack up in the beginning, if you haven't looked at things like potential service charges or, you know, other requirements within the lease. For example, you can't just change a flat. You can't change the layout in a flat without getting your freeholder's consent. You're going to need to pay for an architect or whoever to develop those plans and to get those that consent. And the freeholder can turn around and say, well, actually, this doesn't align with the development, so no. You know, so you need to do your diligence, your research, and ask a lot of questions.
Chris, how does this affect your business as a person who is out there looking to try and improve and build social housing or convert? I mean, we've talked recently about the relaxation on what can or can't be done with existing property. How does it affect that sort of thing?
I'll generally avoid leasehold unless it's the original, unless it's on houses. So I generally won't touch blocks of flats anymore. We'll look at houses if it's the original format of the leasehold, like the ones that the church used basically, the 999-year lease.
Right.
Beyond that, no. Freehold all the way.
It just sounds pain. Zahrah, you've messaged me a couple of things which are really quite interesting. You've said to me privately, people need to learn to challenge the management of companies. Is that a realistic prospect? Can you challenge them?
Yes, you can. That's not my area of law, but I kind of give people a basic outline because a lot of solicitors won't give this during the conveyancing process, but I always explain to my clients with the LP1 pack, which is the leasehold property inquiries. There's a standard form that goes out to freeholders that they're completing as part of the conveyancing process. And one of the questions is, has a Section 20 notice been served? Well, Joe Bloggs is not going to know what a Section 20 notice is. So they're required to consult with the holders if they want to incur a cost of more than £100 a year by contract and £250 for anything else. So even this morning, I saw a story where an elderly lady, her service charges had, quadrupled because of roof repairs, and it's now £400 and something a month. And she's like, I'm a pensioner, I don't get much money, I feel sick receiving this bill. I felt really sorry for her, but they needed to go through a consultation process. The building should have been managed properly, and the management company should be putting money aside for these kind of repairs, not just whacking everybody with a bill.
It does seem awfully unfair. Guys, before we wind this up for today, I just wanted to thank each and every one of you. It's been a really, really thoroughly interesting and slightly upsetting version of Property Quorum. As usual, Hamish, I'm going to leave you with the last word.
Well, I'd be inclined, I think, having listened to what both Zahrah and Juliet have spoken about, to follow Chris's route. Don't go near it. However, the demands of society, the demands on everybody needs to have somewhere they can call home. The demands are out there. People have to get into the accommodation, and some of them do contain leases. Unfortunately, we've got people who can help us through certain aspects of it, but until we get that reform through, the government are running scared. I mean, they're running out of absolutely everything. They're just gasping anyway. And I think the worrisome aspect for them, although they said in their last manifesto they would resolve, have they resolved anything? They would resolve the issues of leases. Whichever way they went, I think Zahrah explained this, whichever way the actual government goes, they're going to upset somebody and upset them badly. So there needs to be that balance. And it is something. And I think I don't know how many times that we've actually had get-togethers to say, so important. Get the right team behind you. Get with you a property lawyer. Get with you that solicitor who knows something about the type of property you're going to buy.
Hear, hear.
For who you choose.
And surround yourself, as Chris has said on many times, with people who know what they're doing. And as Hamish says, and I'm going to echo this as well, try to avoid going for the kind of lawyers, the kind of surveyors who do this almost on a conveyor belt. Try and find people who are going to give you personal attention and also come up with a bespoke solution to your problem, rather than one size fits all. Once again, I need to thank each one of you. Hamish, McLay of Search and Convey, thank you. Chris Gilsenan of Root Home, Juliet Baboolal, our legal from partner of gunnercooke, and of course today's esteemed visitor, Zahrah Aullybocus. I hope I've pronounced that right. Of NEXA Law. I just love these meetings because it is a confluence of a series of ideas, and we don't feel hidebound or bridled by any convention not to talk about some aspect of property law and how it affects you and me. Until next week's Property Quorum, I thank all of you. A shameless plug, it happens every Thursday at 10 o'clock. There's also Property Matters that happens on a Friday, usually between 1:30 and 2. I'm looking forward to this week's. And also I live stream with Chris talking about what's irritating Chris this week in property. And we have some lively discussions there too. please do follow us. We do talk about a wide variety of topics, and we like being driven by the likes of you guys. Oh, thank you very much, Jonathan. He's screaming loudly. I don't know what that means, but I'm hoping it's a good thing. Screaming with joy, of course. Until next week, thank you very much, and goodbye from Property Quorum.